Jefferson County Court at Law is back in session. Court is in session and cause number 318-966. The case is styled the state of Texas versus Cleveland James.
With Jeremy. Jeremy Chambers.
Oh,
There's two
Jeremy.
chambers in your court this morning. Judge.
Oh, okay.
Cleveland and Jeremy. This is Jeremy.
Okay, hold on a minute.
Yes, sir. I think Ms. Barrato represents.
Okay, Jeremy. Okay,
This is Jeremy.
Okay.
She's getting some credit for time.
okay. Court is in session and cause number 322-442. The case is, oh. This thing keep on coming up there. You know what? No, he has two cases. Oh, here it is. Okay, the court is in session and cause number 332-390. Case is styled the state of Texas versus Jeremy Chambers. Mr. Chambers, is that your full name?
Yes, sir.
Mr. Chambers, would you please raise your right hand? Mr. Chambers, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Chambers, you may put your hand down. How are you doing, Mr. Chambers? How are you doing?
Fine. You doing fine?
Yeah.
Okay.
Okay. Mr. Chambers, you here represented by your attorney, Terrence Allison. Attorney Allison, how are you doing?
I'm fine, thank you.
That's good. And Mr. Allison, do you waive a record in Mr. Chambers' case?
Yes, Your Honor.
Mr. Chambers, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you committed the Class B misdemeanor offense of criminal trespassing on or about March 25th of 2022. Mr. Chambers, do you understand what you have been charged with? And to this charge, Mr. Chambers, how do you plead? Guilty, not guilty, or no contest?
Okay.
Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yeah.
All right. Now, Mr. Chambers, I also have before me a document that is titled Misdemeanor Plea Admonishment. It is also labeled as State's Exhibit Number 1. Do you recognize this document?
Sir.
On page 2 of this same document, there are a set of initials, JC, that are on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials, JC, on this document?
Yes, sir.
Hold on. Ma'am, you need to have a seat. No, you. Give her a tip. Hold on. You do? Okay. And on page 3 of the same document, Mr. Chambers, there is a signature above the line that is titled Defendant. Mr. Chambers, is this your signature?
Yes, sir.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Sir.
And is this your signature above the line that's titled Defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
And Mr. Chambers, I also have before me a document that is titled Discovery Certification. Mr. Chambers, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Chambers, before you signed and initialed these documents that I've just mentioned to you, did your attorney, Attorney Allison, go over these documents with you?
Yes, sir.
And did you read and understand everything that he went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Chambers, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit Number 1, the misdemeanor plea admonishment, and State's Exhibit Number 2 in the court's file, the probable cause affidavit. State, you like to offer States 1 and 2?
Yes, Your Honor, it offers state one and state two.
Okay, no objection. State's Exhibits 1 and 2 are admitted. Mr. Allison, you advising counsel, Mr. Chambers, is there any evidence that he is currently mentally incompetent to stand trial?
Well, he is competent.
Mr. Chambers, your attorney, Mr. Allison has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Chambers, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, in exchange for defendant's plea of no contest in this case, the state recommends confinement in the Jefferson County Jail for a period of 8 days, Your Honor. We're asking that the court give defendant credit for the 8 days previously spent in jail, making it the time served plea agreement, Your Honor. And lastly, we're asking that the court use the time served for both tax and retirement court costs.
Mr. Chambers, the state is offering that you serve 8 days in the Jefferson County Jail. However, you will not have to serve any more time in the Jefferson County Jail on this case because you've already served 8 days in the Jefferson County Jail. Therefore, you will be given credit for the time that you have already served. The court cost in this case is $337, but you will not have to pay the court cost because the time that you spent in jail has already paid it off. Therefore, the court cost will be taxed and retired. Mr. Chambers, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Chambers, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Chambers, you're gonna stand on the X next to your attorney. You're gonna follow the directions of the clerk. Once you finish following her directions, you'll be free to go and you have a blessed day. And Mr. Allison, you'll be free to go as well and you have a blessed day. It's cause number 332750. Case is style, the state of Texas versus Machila, Oshana, Joseph, Isaac.
That's right, Judge.
Yeah. Is that Machila? Michaela?
Yes, sir.
Okay. Okay, Miss Joseph Isaac, how are you doing? I'm doing fine, thanks for asking. And Miss Joseph Isaac, you're here represented by your attorney, Attorney Tom Burbank. Attorney Burbank, how are you doing? Mr. Burbank, and the state is represented by Attorney Ray Shearer. Attorney Shearer, how are you doing? Mr. Burbank, what is your announcement in Miss Joseph Isaac's case?
The state has given her a new offer reduction to JP. She
Okay.
about 30 to 45 days. Take care of that.
Okay, how you need 30 or how much, 30 or 45 days? Okay, give us a date. January, it's reset to January 13th. Okay, okay, 2023. And Mr. Burbank, you can get your reset. Once you get your reset from your attorney, you'll be free to go and you have a blessed day.
See how-
Kenny Banks, is Kenny Banks here?
I need a bill.
Mr. Bailiff, would you please call the name of Kenny Banks at the courthouse door? Kenny Banks, yes.
No response.
Okay. Kenny Trayvon Banks was scheduled to be in court in cause number 330464 at 9 a.m. At or about 9 a.m. The court's bailiff called the name of Kenny Banks at the courthouse door. The time now is 10:07 a.m. on today's date of November 4th of 2022. And Mr. Banks has not appeared since the court's been in session. His attorney Tom Burbank is here. The court has given Mr. Banks a reasonable time to appear in court. He has not appeared in court. State, do you have a motion?
Yes, Your Honor, they move for bond.
That motion will be granted. Kenny Banks' bond will be forfeited and a warrant shall be issued for his arrest in cause number 330464. And Mr. Burbank, I think this is your last case.
That is.
Okay, you're free to go and you have a blessed day.
Thank you.
And Mr. Kimler, you're free to go as well. You have a blessed day. Your client has been taken into custody.
Yes, sir. Thank you.
All right. That was reset, huh? And do what? Yeah. 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 Okay, this is cause number 32019, case of South State of Texas versus Jacoby. What's that, Joel Petrie? How you doing, Mr. Petrie? I'm doing fine. Mr. Petrie, you're here on a motion to revoke probation. And Mr. Gilliam is with the probation office. What's the recommendation?
So we'd like to reset for 60 days. He has a outstanding balance of $2,000. He says he can have it done in 30. I think 60 is more appropriate.
Is that correct? Okay. So we're gonna reset it for about 60 days? Okay. Just have a seat, and then the court coordinator, when she comes back in, she's gonna give you a reset date. Okay, I'll go with her. This is cause number 332-420, case of South State of Texas versus Courtney Elaine Hutchins. Ms. Hutchins, is that your full name?
Yes, sir.
Okay, now, Ms. Hutchins, how are you doing?
I'm doing good. How about you?
I'm doing fine, thanks for asking. Now, Ms. Hutchins, the last time you appeared for arraignment, you appeared via Zoom, and you were asked to come in to make your choice as to an attorney. Now, the document that you have before you is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you see that document?
Yes, sir.
I'll go over this document with you, and it reads, as a defendant in the criminal case, you have three options. Number one, you may hire an attorney. Do you understand that option? Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option?
Yes, Your Honor.
And number three, you may represent yourself. Do you understand that option?
Yes, Your Honor.
If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you would need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to waive your right to an attorney and represent yourself, you may not speak to a prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Do you understand that?
Yes, sir.
At the bottom of the document in bold print, it states defendant's choice. Mark initials next to only one choice. If your choice is I want to reset my case to hire my own attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you in this case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you want to waive your right to an attorney, which is that means you want to give up your right to have an attorney and to represent yourself, then you'll put your initials on the 5th line to the left. Now, once you finish initialing one of the 5 lines, then you will sign your signature on the line that is titled defendant, and you will date it today's date on the line that's titled date, and today's date is November 4th of 2022. Do you understand?
Yeah.
Okay. Okay, Mr. Porter. Hand that sheet. Okay, now, the bailiff is going to give you a document that is titled Jefferson County Affidavit of Indigence. You'll fill that document out. And basically on that document, you're gonna fill the top information, that's your name, your address, telephone numbers. It also will have information concerning your employment, if you're employed anywhere, or if you receive any type of governmental benefits. It also, if you have any children, 18 years old or younger, you're gonna fill that information out. And then you'll fill out the information about your housing, whether or not you own a home, you're renting, you're living with a relative, or whether or not you're homeless. And then on the bottom left-hand side is gonna ask for your income information, your monthly income, if you are employed, whether or not you have a spouse, and if your spouse monthly income. It will also ask information as to whether or not you're receiving child support. And if you have any type of governmental benefits, you're gonna put that on the document. And then it will also ask whether or not you have any assets, like a car, a house, and you put the value of that on the left-hand side. And then once you get to the bottom of that document, on the left-hand side, it says total. You will total up everything in the column. Then you go to the right-hand side, and it asks for monthly expenses. And it talks about your mortgage, your rent, also your utilities, and then it'll ask whether or not you are that you're paying child support, and also your food expenses. And then the part about transportation, that basically entails not only if you have a car note, but if you're paying your insurance on the car, and as well as the gas expenses on maintenance. All right. Now, when you talk about food expenses that you're responsible for, if you have children, you're going to include that as well. Okay, and then the other things is probation fees, medical expenses, and then once you get to the bottom, you're going to total up everything in that column. And then you go to the next page at the top, it has an oath. You're going to fill that information out today, read it, and then sign your name and today's date. And then at the bottom, it asks for an unsworn statement. You're going to fill out the information there. And then once you do that, you'll be complete. You'll be finished with the form. Okay, so you have a pen and a clipboard. Just have a seat in the gallery. And then when you finish with that document, we'll call you back up and we'll let you know whether or not you meet the eligibility requirements for the appointment of a court-appointed attorney.
Thank you.
You're welcome. Okay, Mr. Petrie. Okay, Mr. Petrie, you have a blessed day.
We're ready on that.
Next case is cause number 332422. That's Scholastic Remenia Boyd. This is cause number 332422, case of Style State of Texas versus Scholastic Remenia Boyd. Ms. Boyd, is that your full name?
Yes, sir. Scholastic Q.
Hmm?
Scholastic.
Oh,
Q.
Scholastic Q?
Yes, sir.
Okay, Scholastic Q Remenia,
Raymond Boyd.
Remenia Boyd. How you doing, Ms. Boyd?
I'm fine. You doing all right?
I'm doing fine. Thanks for asking. Whose phone? Ms. Boyd, you're here represented by your attorney Don Boudreaux. Attorney Boudreaux, how are you doing?
Just fine, sir.
That's good. Mr. Boudreaux, it's my understanding that the state is filing first of all, I have before me a motion to forfeit the bond, a motion to forfeit a weapon in cause number 332422. Now, Ms. Boyd, would you please raise your right hand? Ms. Boyd, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Now, Ms. Boyd, I have before me a motion to forfeit a weapon in cause number 332422. Do you recognize this motion to forfeit?
Yes, sir.
And Ms. Boyd, is this your signature on the
Yes, sir.
line that's tied to defendant?
Yes, sir.
Now, Ms. Boyd, before you sign this document, did your attorney, Mr. Boudreaux, go over this document with you?
Yes, sir.
And did you read and understand everything in this document?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, now, Ms. Boyd, I've read this motion that was filed by the Jefferson County DA's office, and the court is going to grant this motion, and the weapon in this case will be forfeited to the Beaumont Police Department. State, do you have an additional motion?
Yes, Your Honor, the state will be moving to dismiss this case called number 332422 in consideration for the forfeiture of the weapon and defendant's pleading in felony case number 22-39911.
Okay, and I have a copy of this motion to dismiss. Now, Ms. Boyd, the state will be dismissing this case. I'm signing the motion right now. Okay, now, Ms. Boyd, I just signed a motion to dismiss. Your attorney will be able to get a copy of this motion to dismiss. This will conclude your case. Let me pass this over here. Ms. Redmond, could you make a copy of that? Ms. Boyd, once you get a copy of the motion to dismiss, you'll be free to go, and you have a blessed day.
Yes, sir. You too.
And Mr. Boudreaux, once you get a copy, you'll be free. I think this is your only case.
Yes.
You'll be free to go as well, and you have a blessed day.
Thank you, sir.
Okay.
Oh,
I want you to sign something.
it'll be just a second.
Sure.
Okay, she's gonna go make a copy.
Mr. Did we ever, y'all ever made a decision on Vasquez?
Your Honor, we'd like to go ahead and rescind for plea.
Okay,
Just a plea of true on the MPRP, but I was gonna try to move it later so you can get all of the business things done.
okay, okay. You get with the court coordinator, get your reset. Okay. That leaves us with change. And on this docket. Said 1:30. Burbank, Justin Galmore, okay. It is cloud. Mr. Galmore. Dustin.
Morning, Judge.
You're representing John McDowell
Yes, Judge. He's on, I think he's on the, on Zoom.
on Zoom. Yeah, Mr. McDowell, you can take your mic off of mute. This is cause number 331162. Case is styled the state of Texas versus John Philip McDowell. Mr. McDowell, how are you doing?
I'm doing good. How are you doing, Judge?
I'm doing fine. Thanks for asking. Mr. McDowell, you're represented here by your attorney Dustin Galmore. Attorney Galmore, how are you doing? Attorney Galmore? Let's have some problems. Your attorney must be having some technical difficulties.
I'm here. Sorry about that, Judge. I think my internet, messed up for a second.
Okay, okay. Now, Mr. Galmore, what is your announcement in Mr. McDowell's case?
Judge, we would like one additional announcement date. Needed to get the videos available to Mr. McDowell, and we've done that. So we'll be able to announce it our next court date.
Okay, just hold on a minute. I'm gonna need a reset on John McDowell on the announcement docket in the middle. He's on Zoom. Okay, this case will be reset to January 13th of 2023. Mr. Galmore, your reset will be sent to you. Mr. McDowell, your attorney, your bondsman will be given notice of your reset. Stay in contact with your attorney and your bondsman. You're free to go, and you have a blessed day.
Thank you, Your Honor.
And Mr. Galmore, I think this is your only case, so you're free to go as well, and you have a blessed day.
Yes, sir. Thank you, Judge. You have a good weekend.
All right, the same to you.
I'll tell you what, it's so much more convenient than driving to a courthouse, getting out of my car, walking in the courtroom, sitting around for 30 minutes. That's one good thing about COVID was that is a lot more.
I had to remove him. I don't think he intended for us to hear that. Case is styled the state of Texas versus Albert William Burnson. Okay. Okay, this is cause number 332776, case is styled the state of Texas versus Albert William Burnson. Mr. Burnson, is that your full name?
Yes, sir.
Mr. Burnson, would you please raise your right hand? Mr. Burnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Burnson, you may put your hand down. How are you doing, Mr. Burnson?
I'm doing good.
I'm doing fine. Thanks for asking, Mr. Burnson. You're here representing by your attorney. And Mr. Cole, Mr. Giles Cole. Mr. Cole, how are you doing?
Great, Your Honor.
And I'm doing fine. And Mr. Cole, do you waive a record in Mr. Burnson's case?
Yes, Your Honor.
Mr. Burnson, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. This information alleges that on or about February 11 of 2022, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Burnson, do you understand what you've been charged with?
Yes, Your Honor.
And to this charge, Mr. Burnson, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Burnson, I also have before me a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of initials on a line next to a box that says check nola contendere. Are these your initials?
AB.
That's your
Yes,
initials
sir.
on the line, on this document? Okay. And on page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
Now, is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that
Yes, sir.
statement? Mr. Burns, okay, there it is. Mr. Burnson, I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Burnson, before you signed and initialed all of these documents that I've just mentioned to you, did your attorney go over these documents with you?
Yes, Your Honor.
And did you read and understand everything that he went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Burnson, are you a citizen of the United States?
I am.
State, I have before me State's Exhibit Number 1, state, you like to offer State's 1?
Yes, Your Honor. State offer state.
And I also have State's Exhibit Number 2, the probable cause affidavit. The state also like to offer State's Number 2.
Yes, Your Honor. State offer state 2 as well.
No objection.
No objection, States 1 and 2 are admitted. Mr. Cole, you've advised and counseled Mr. Burnson. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Burnson, your attorney, Mr. Cole, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes.
Mr. Burnson, I will accept your plea of no contest. I will find that you're mentally competent to stand trial. I will also find that you're pleading waivers were freely and voluntarily given. I also find that there is sufficient evidence to find you guilty beyond a reasonable doubt state. Do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, in exchange for defendant's plea of no contest in this case, the state is recommending confinement in the Jefferson County for a period of 180 days, Your Honor. We're asking that the court suspend imposing that sentence at this time and instead place defendant on community supervision for a period of 1 year, Your Honor. Require defendant to pay a $1,000 fine to complete 80 hours of community service, and for the standard DWI probation conditions to include DWI education course, drug and alcohol assessment, plus an interlocutor fight.
Okay. Mr. Burnson,
Yes, sir.
the state is offering that you serve 180 days in the Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail in this case because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $1,000 plus court costs of $422. The total fine and court cost is $1,422. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll be required to reimburse Jefferson County court-appointed attorney's fees of $250. You will also be required to pay Jefferson County DWI education class and initial evaluation fee of $125 on the day of the plea. Should a full evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $230 a month. Will you be able to pay the $230 each month?
Yes, Your Honor.
Okay. Mr. Burnson, you also be required to perform 80 hours of community service. You'll be required to install a DWI interlock device on any vehicle that you own or operate. You'll be required to attend and complete a DWI education class and have a drug and alcohol assessment. And you'll also be required to adhere to the other standard terms and conditions of this probation. Now, Mr. Burnson, do you understand the state's offer?
Yes, Your Honor.
Do you think that the state's offer in this case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, I do.
Okay, Mr. Burnson, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Burnson, you're gonna stand on the X next to your attorney, follow the directions of our clerk. Once you finish following the directions of the clerk, you'll be free to go, and you have a blessed day.
Yes, sir.
And Mr. Corley, once you finish signing the probation papers, you'll be free to go as well, and you have a blessed day.
Good. Now, this is a-
Yes, is it on there?
Someone in the court, her name is Courtney Hudson.
Is that-
I'm gonna be, she was filling out the indigency affidavit. I'm going to be representing her.
So you're gonna, okay, so you're gonna do a letter of
Yes, I
rep-
will, if I, yes, sir.
So, what we need to do, Ms. Hutchins? What you need to do is, this is it. I think this is it right here. She's gonna have to make a change on there that's saying that she wants to, she's gonna hire an attorney. You see at the bottom? She signed the third one. She's gonna change it to the first one. She wants the case reset to hire an attorney. Oh, don't put them in your pocket, man. I done messed up some shirts.
I know, they were terrible. Oh,
I got some shirts that I hate to get rid of.
I know.
Yeah, okay, so, we're gonna reset her case. Give us a reset date.
Who gets this? Oh,
Yeah.
let me have that.
Yeah.
To the judge. I'm like, I don't know what to do.
Okay. Could you give us a reset date? Okay, Ms. Hutchins, your case is gonna be reset to January the 13th to give you an opportunity to hire your attorney. Ms. Hutchins, you're gonna stand on the X, you're gonna sign on the pad over on 4X, you're gonna sign on the pad. Once you sign on the pad, you'll be free to go, and you have a blessed day. All right. Let's see.
That's easy to process.
Here you go. Who you said, Baptiste? Jordan Baptiste? And get Fernando Cabrera as well. This is cause number 332432. Case is style of State of Texas versus Jordan Latre Baptiste. Mr. Baptiste, is that your full name?
Yes, sir.
How you doing, Mr. Baptiste?
Okay.
Okay, now, Mr. Baptiste, your case was reset to give you an opportunity to hire your attorney. Have you hired your attorney?
No, sir, not at the moment.
Okay, why haven't you hired your attorney?
I am going out work due to a back injury that never hired attorney.
So now you're telling the court that you're unable to hire an attorney right now as well?
Oh, I can now. I'm back working, and I was just looking for prices right now.
Okay, so we're gonna reset his case, give him an opportunity to hire his attorney. Give us a reset date. Okay, this case gonna be reset January 13th to give you an opportunity to hire your attorney. You're gonna stand on the X in front of our court coordinator. Once you get your reset, you'll be free to go, and you have a blessed day.
All right, thank you.
You're welcome. Fernando Cabrera. This is cause number 332-902, case of style of state of Texas versus Fernando Cabrera. Mr. Cabrera, is that your full name? How you doing, Mr. Cabrera? I'm doing fine, thanks for asking. Mr. Cabrera, your case was reset to give you an opportunity to hire an attorney. Have you hired an attorney?
I haven't been able to, I need a couple more weeks.
You need a couple of more weeks to do that? Okay, Mr. Cabrera, we're gonna reset your case. And she's gonna our court coordinator is gonna reset your case, give you the time that you need to hire your attorney. Once you get your reset, you'll be free to go, and you have a blessed day. Please stand on there behind this gentleman right here. And once you can stand over there against the wall, sir. What do we, this is cause number 331-936, case of style of state of Texas versus Michael Ravine Peterson. Excuse me, do you pronounce it Michael?
Michael Raven.
Michael Raven Peterson? Okay, how you doing, Ms. Peterson? That's good, Ms. Peterson, you're here represented by your attorney, Marva Provo. Attorney Provo, how you doing? Okay, now, Ms. Provo, what is your announcement in Ms. Peterson's case?
Your Honor, we would like to, we have reached an understanding with the state, but we need some time to, we can collect some money for her fine that we will agree upon, at least another, announcement, 60 days.
Okay, give us you have any objections, state?
Oh, no, no objection.
Okay. We have Ms. Peterson. Could you give Ms. Peterson a reset date? Okay. This case, Ms. Peterson, will be reset to January 13th, give you opportunity to save the money that you need to pay the fine. Now, your attorney is going to get your reset. Stay in contact with your attorney. Once she's going to give you a reset, once you get your reset, you'll be free to go and you have a blessed day. And Ms. Provo, you'll be free to go as well and you have a blessed day.
Okay, thank you. May we be excused?
Yes, you may be excused. What they got going on there? Okay. Okay. This case is this all? Wow. Oh, they gave it to us back on our. Okay. We can, yeah. This is, Ms. McGuire's bond conditions.
Okay.
That's about a bondsman. We're gonna, put that in the, hmm? Who? Yeah, so she had some bond, so her bond is being revoked.
I see that it says that she's required to submit, but it doesn't give any
For real?
consequence of,
Yeah,
you know, even if you don't submit.
yeah,
Uh,
right.
And Your Honor, on our other contestant that was here just a second ago that had the warrant. I just wanted the court to be aware that he's also out on bond on DWI, and the charge, the warrant is a resisting arrest.
Right, I
He
know.
was charged with public intoxication. And
Say that again?
so he was charged with public intoxication at a bar and
Oh,
resisted
wow.
arrest. And so, and he's out on bond for DWI.
Yeah.
So, you know.
Did we
that's-
have bond condition? I
on
don't
a
think he ever
DWI,
came.
He's gonna have to have.
I don't know if he ever came. Yeah, because he appeared via Zoom. I know I didn't give him to him. Maybe because this is his first time here
Okay,
on in person.
okay.
I think that's what it is. It he came before? Okay, look at the look in the Okay, give me that back. And give me the test back. The test results. And we're gonna put this on the record. Yeah. Ms. Matoir, you can come on up. Okay. This is cause number 332118. Case of South State of Texas versus Lanisha Renee Dene Matoir. Ms. Matoir, I have before me standard bond conditions in county court at law. It says county court of 3, but it's bond conditions on the case that you are on. And in this case, Ms. Matoir, these bond conditions was given to you on May 26th of 2022. Let's see, give me go in her file. She should have her bond on there, her bond information. And she made bond. Right. That's what I need. Give me, print that off. Okay, now on in this case, clause number 332118, Ms. Matoir, you made bond with Pete Day, and as a condition of your bond, you were given standard bond conditions. And Mr. Bailey, could you hand this to Ms. Matoir? And Ms. Matoir, do you see that document that the bailiff just handed you? You have to speak up.
Yes, sir.
Now, is that your signature on that document?
Yes, sir.
Okay. Now, Ms. Matoir, as a standard bond conditions, you were required to submit to any test for drugs and alcohol at the direction of the court. Is that correct? Condition number 2. Okay, could you hand that back to me? And I'll just read condition number 2. It states that the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. And so the court on today's date of November 4th of 2022 ordered you to have a drug test, and you were given a drug test, and we can show her a copy of that drug test. And you tested positive for 3 drugs. One was THC, the other one was opiates, and the other one was benzodiazepine. Is that correct? And I think you initially informed the probation office that you probably would test positive for the THC, which is the marijuana. Is that correct? Okay. So, state, you have a motion?
The state would like to see an increase on the bond.
Okay, that bond will be that increase will be granted. So, Ms. McGuire, your bond has been increased. Just please follow the bailiff. Oh, I don't need it now. Okay, but I'm working on the. Yeah. Here you go. Okay, Mr. Cobb need a reset on his case.
I think I already have.
You already have it?
We're already done.
Okay, we're done with your cases. That's
Yes,
good.
sir.
Okay, so we have Mr. Crocker. Okay, this is clause number 329824. case of style of state of Texas versus Jacob Perry Wright. Mr. Crocker, Mr. Wright. Miss. Okay, this is cause number 329-824, case of South State of Texas versus Jacob Perry Wright. Mr. Wright, is that your full name?
Yes, sir.
Mr. Wright, how are you doing?
I'm doing great. How about yourself?
I'm doing fine, thanks for asking. Mr. Wright, you're here represented by your attorney Glenn Crocker. Attorney Crocker, how are you doing?
Good morning, Your Honor. I'm well, thank you.
Okay, thank you. Now, Mr. Crocker, you filed the motion to modify conditions of community supervision, is that correct?
That is correct, Your Honor.
And Mr. Crocker, are you ready to proceed?
I'm ready to go, Your Honor.
State, are you ready to proceed?
Thank you, Your Honor.
Okay, Mr. Crocker, you may proceed.
Thank you, Your Honor. Would the court prefer to do this by summation and submission or testimony?
Either way, we fine. I mean, but it normally, well, we have a court reporter here.
Okay.
Yeah.
Well, then I will call my client, Mr. Jacob Wright. Mr. Wright, state your name.
Jacob Perry Wright.
And you're the same Jacob Wright that was convicted on March 14, 2022 at DWI.
Yes, sir.
And you were sentenced to a year of probation here in Jefferson County, Texas, correct?
Yes, sir. That is correct.
We are now a little over 6 months into it. Have you completed all the terms and conditions of your probation?
Yes.
All the community service?
Yes, sir.
All the fines?
Yes, sir.
All the fees?
Yes, sir.
You've reported
Yes, sir.
and you have not violated any terms or conditions,
That's
correct? One of the conditions of probation was that you had an interlock ignition device placed on your vehicle, is that correct?
That is correct.
And you're asking that device be removed at this time.
Yes, sir.
Can you explain to the court the nature of your request and why you were asking that it be removed?
We're actually expecting December 14th. We're supposed to have a baby and she has to have a C-section. So if she goes into labor at any time, I have to be able to jump in and haul her to the hospital so they can stop it. So with being with the interlock in my truck, it's going to make it kind of hard if she's going into labor, because with a C-section, she has to have it stopped and they have to be able to go in and emergency take the baby.
Explain to me why the interlock ignition device would prevent you from making an emergency trip to the hospital.
It takes a good minute for it. Once you run your breath through it and all that, it takes about a good 2 to 3 minutes for it to crank up before you can drive. And then trying to rush, it goes off periodically. To me, it's dangerous when you're trying to get somewhere in a timely manner, to not break the law and having this thing going off. And if you don't blow into it, it automatically forces a force fail.
During this course of probation, have you had any issues with the interlock ignition device?
Not this one, the first one I did.
Can you explain to the court what the issues were initially?
The first interlock I had, it actually, when you would hit a bump, the whole interlock would just shut off. And it got to the point where I couldn't get my trunk cranked. I got stuck at work 2 or 3 times. I had to get under there and wiggle wires in the dashboard. I had to wiggle the battery, got it on enough to cut on to blow into it to get it, and had to take off work and have it removed I had to go to Cleveland, the other side of Cleveland, to have it removed because I couldn't afford to be stranded at work like it was leaving me. And be driving down the middle of the highway, it would just completely shut off.
During the time in which you've had the interlock ignition device installed on your vehicle, have you had any, what I'm gonna deem or term positives, meaning it detected alcohol on your breath and shut
No,
down? Are you no longer consuming alcohol?
that is correct.
And how much longer do you have left on probation?
March 13th is my last day of probation.
So you get a couple more
Yes, sir.
months left.
Yes, sir, that is correct.
We have stated in our motion that you were wanting to go see your grandparents in Uvalde, Texas.
Yes,
Can you explain to the court why the ignition interlock device would be problematic for you going to Uvalde?
6-hour trip. If I was to get up there and it, for some reason, malfunction or something like that, I won't be able to get back home and come back to work for my vacation. It's a risk that I'm taking driving it up there. Like I said, if it malfunctions even on the trip during the drive, you know, like I said, it goes off periodically. It's going to be, if I leave it out Sunday night, it's going to be a late night trying to drive through heavy traffic with that thing periodically going on and trying to follow the GPS maps.
It's safe to say that you don't hold a whole lot of confidence in this device.
No, sir. It's to me, I understand why I had it and I agree with it, but for the long run, that's, to me, it's kind of a safety issue, especially when it pours down rain or something and constantly when it blows going off, you have to pick it up, trying to drive one-handed down the highway and hold it and blow into it.
There's a term and condition of your bond where you're required to have an interlock ignition device.
Yes, sir.
And how long were you on bond?
I cannot remember.
Best of your ability over a year, right?
Yes, sir.
Your Honor, I pass the witness.
Okay, Mr. Johnson.
Sure, Your Honor, just a couple of questions. I'm Lamar Johnson, I haven't had a
Nice
chance
to
to
meet
meet you yet. Obviously, DWIs and especially dealing with alcohol is an issue plaguing
Right.
Jefferson County. What assurances will you have that, you know, if the judge granted your request to remove the interlock device, that, you know, you wouldn't have to hop in the car now?
No, I'm not. I've definitely learned from this. And this was I have family in the police force and all that, and this was definitely an eye opener for me. I will not be back in here for anything like that ever again. I've definitely learned my lesson. I have no need to do that ever again.
No further questions, Your Honor.
Okay. Anything else?
No, Your Honor, nothing else.
Okay, court is gonna take this matter under advisement. Okay. I mean, I was just taking some notes down here. So, we're going to, I'll take it under advisement. I'll probably give a ruling. That's right, we're not here next Friday, right? Just, give us a reset date. Well, we'll put
Next week or the week after this?
no, probably week after, I would imagine. Because I think next week we down on that Friday, if I'm not mistaken. That's Veterans Day, isn't it?
Yeah, there's some kind of holiday next.
Yes, Veterans Day
Go with it.
on a Friday.
It'll be the 18th, but I'm not- I'm looking for the
Okay.
18th.
She says she thinks she is.
Okay.
Okay, we're gonna reset it to the 18th. Okay, we're gonna reset it November 18th, okay. All right, Mr. Crocker, you get your reset. And Mr. Wright, once you get your reset from your attorney, you'll be free to go and you have a blessed day. And you have a blessed day as well, Mr. Crocker. Okay. Okay, you're welcome. This is cause number 317312. Case is style of state of Texas versus John Culver. Mr. Culver, is that your full name?
Yes, sir. John Albert Cole.
Mr. Culver, how are you doing?
Very good. I'm breathing. Just got a new job.
Oh, that's good.
And because I've been fighting for disability since 2018.
Okay. Now, Mr. Culver, your case was set on the court's Capri's profile docket. And Mr. Culver, I see here that you had a judgment that was rendered. In essence, you entered a plea of guilty on June 27th of 2018. Your fine was assessed $1,000 plus court costs. The fine and court costs at that time came to a total of $1,252. And the court has sent you notice to appear on today to answer to this Capri's profile to see, one, whether or not you made payments, whether or not you paid on the profile, on the fine and court costs or not, and to determine whether or not you had an inability to pay.
I was working out of state. I said she was paying for it. When I got the letter from y'all, that's when I found out that it wasn't paid. I'm here to see if I can start making payments.
Okay, so you're telling the court that you can make payments on
Yes, sir.
okay, on this. Okay, so what the court can do, the court can give you an opportunity to make your payments. Now, let me ask you, so you said that you was giving the money to your wife. Oh, well, you was working out of state.
Yes,
your
sir.
wife was supposed to be making the payments. She
Yes,
wasn't
sir.
making the payments.
I did not know that she was not making payments off. I did not know that she was using my money for drugs either. We are not together anymore.
Okay,
And it's the company that I'm working for now is I was working for out of state. That's the reason why I got the job, is because the doctor says I cannot pick up anything more than 10 pounds. And they just put me in a foreman's position. So all I have to do is pretty much do paperwork.
okay, so you had an inability, I mean, you were off or something?
Yes, sir. I was off since March 2020. And of course, it was because of the pandemic. And then I got into a wreck in December.
Okay,
My L1 was completely destroyed. They had to go in, put pins, rods, and needles in. My bad.
okay. Let me do this. Could we check to see how much did you, now, when you were initially arrested on the case,
Yes, sir.
do you know how much time you spent in jail?
Honestly, I don't remember any of that.
Okay, could we check? Hold on a minute.
He got out the same day, so,
Okay,
11/19 and out 11/19.
okay. And will you ever rearrested on it again?
No, sir.
Never
I was not.
rearrested.
No, sir.
And then what we're gonna do, we're gonna give you that 1-day credit toward your fine and court costs.
Yes, sir.
So that'll be $100 that's gonna be taken, it's gonna be lowered by $100.
Okay.
Okay? So what we're gonna do, we're gonna give him that 1-day credit toward his that fine and court costs of $1,252. And then you'll be required to pay the remaining balance, $1,152. The court is going to take into consideration that during this time, you had an inability to pay, in that you stated you was COVID, not COVID, but it was during COVID.
Yes, sir.
And then you were out of work, and then you had an injury.
Yes, sir.
that you were out of work as well?
Yes, sir.
Okay, so the court is gonna also take that into consideration. Now, what we're gonna do, the court is gonna give you an opportunity to pay off the remaining balance.
Okay.
Now, do you have any idea how much you may be able to pay on a monthly basis?
$400. To be
Wow,
honest with
you
you, as
say
soon as
that-
I walk out of here, I'll be able to go put $100 down. Just like I said, I just started my work. I mean, if I can.
Okay, you have to make that payment down at the sheriff's office. That's where it's paid, right? I think so. I think the payments are made when a person have a fine and court cost. They make those payments to at the sheriff's office.
Take that back. That's over that way, right?
Right.
Okay, thank you.
Okay, so just, so what we're gonna do, we're gonna give him $100 credit toward his fine and court costs. That's gonna lower the amount that he owed to $11.52. And, he said he's gonna make $100 payment today. And then you wanna pay $400 a month, that's what you said?
Yes, sir.
Okay, so if you do
I'll
that.
try to pay it off as fast as I can. You asked me
Right,
a
that'll be
number.
off, that'll probably be paid in 3 months.
Yes.
Okay, just have a seat. Okay, we'll call you back up. Now, we ready for our next case, who's gonna be handling that? Ms. Perazzo? You're gonna have a seat at council table? Is it contested hearing, right? Who's, you're gonna sit at the table with your attorney? Yeah, we Court is back in session in two cases. The first case is cause number 318966. Second case is cause number 322442. First case is styled the state of Texas versus Cleveland James Chambers. The second case is styled the state of Texas versus Cleveland J. Chambers. And we have Mr. Chambers in court with his attorney, Attorney Lori Perazzo. I have before me a motion, well, and we also have the State Assistant District Attorney, Attorney Raymond Shearer. And I have before me two motions to revoke probation. One motion is in cause number 328966. The second motion is in cause number 322442. State, are you ready to proceed?
State's ready, Your Honor.
Defense, are you ready to proceed?
Defense is ready, Your Honor.
Mr. Shearer, you may proceed.
State would like to call Alex Parsons.
Okay. Mr. Parsons, let's do this here. Mr. Parsons, you come forward. You're gonna turn the camera toward them. Mr. Parsons, would you please raise your right hand? Let me do this here. Okay, Mr. Parsons, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Mr. Parsons, you may put your hand down. You can have a seat in that witness chair on the witness stand. Move that clipboard. Mr. Parsons, you can adjust the mic. Mr. You have to move that podium. You gotta move that podium so they can ask questions on the podium. Mr. Shearer, you may proceed.
Parsons, could you please tell for who you are?
My name is Alex Parsons. I'm a probation officer for Jefferson County.
And as a probation officer for Jefferson County Probation Office, do you have occasion put input into the system? You'll have keeping track of people on probation.
That is correct.
Okay, and in relation to this case, of course, we have two cases in Chambers. Are you familiar with these cases?
Yes, I am.
How are you familiar with them?
I am the current supervision officer in the elderly caseload that he is particularly on, while pending motion to go to this case.
And so, as part of y'all's probation office, who all has access to the record?
That would be probation officers and other authorized officials that would be permitted access to the data entry system.
Okay, and are you confident that the information that you have was accurately entered in the system?
Yes.
Okay, and has this information been entered in the system by you?
Some of which, yes, pertaining to the status of this case being that it's pending a revocation hearing, along with I believe there was an inquiry where he had reached out to me about an anger management class. He was provided referral resources at that time.
Okay, and the court take notice that the state's referring to the motion to revoke probation that has been filed. In this motion, it stated that Mr. Chambers failed to report to the Jefferson County Probation Office as ordered by the court on June 3rd of 2022, 8th, 2020. Well, 2020 and September 21st, 2020. Do you know if that's accurate?
That is what's in the record, yes.
Okay, and just also since that time, has he reported to the office?
Not since the end of the original term of expiration of this case, which would have been January 13, 2021.
Okay, do you know if he has paid his court assessed fees?
He currently has arrearages on both cases.
Okay, do you know the amount of those arrearages?
I do. It appears on calls number 318966 that he is currently $647 in arrears. And on calls number 322442, he is $399 in arrears.
Okay, and in reference to his community service hours, what's the status there?
Good. He has not completed the obligation towards calls number 322442. I'm showing in the records that he has worked a total of 22 hours out of the originally assigned 60 hours, which leaves him with a remaining balance of 38 hours, with hours last worked what appears to be December 18th of 2020.
Okay, and in reference to anger management program, how is the anger management administered those courses?
Okay. Normally, the probation officer will provide referral resources either at intake or throughout various office visits for the probationer to follow up with resources to enroll and subsequently pay for classes provided.
Okay, and those classes, are they in-person classes?
I do think that there was a period of time where they were doing them remotely at Family Services, which is the referral agency, due to the pandemic and other changes that had occurred. But I do believe that now they are currently resuming with in-person group.
Okay, so during the time that we're talking about that Mr. Chambers was supposed to be enrolled in anger management, was the online option available?
I'm not certain.
Okay.
I believe it was, but I don't want to say it was and it not be so.
Okay, that's fine. Okay, and in your position as supervisor at adult probation, what is your feeling about what the court should do on this?
The recommendation from probation is for revocation of this probation claims, given the violations that are mentioned in the motions to revoke.
No further this time.
Okay. Ms. Peraza?
I apologize. Can you tell me your name again?
My name is Alex Parsons.
Mr. Parsons, have you ever met personally with Cleveland Chambers?
No,
And how long has been a supervisor over his case?
since April of 2022.
You have the pay record with you, I presume, for both cases, correct?
Yes, ma'am.
Can you tell me, and I don't really want to take up too much time of the court's, or too much of the court's time, but can you tell me, since the motion to revoke probation was filed back on October 23rd of 2020, how much or how many payments for each case have been made or towards each case by Mr. Chambers?
You said October 3rd of 2020?
Well, the motion to revoke probation was filed on October 23rd of 2020. So after that motion to revoke probation is filed, in those cases, and I'm specifically looking at cause number 322442. But after that date in October of 2020, can you tell me how many payments, the total amount of payments that were made on each case?
So for clarification, the total amount of how much he's paid or how much is in arrears?
How much he paid?
Okay, I'm showing that for cause number 322442, he has made a total amount payment of $217. And in cause number 318966, it appears that he has paid $1,047 for those fees.
Okay. Would you say the print shows that he's making an effort towards making payments towards his arrears?
It reflects that he's making payments.
Okay. And when were the 22 hours of community service exercise or performed by Mr. Chambers? Are you aware of that?
Yes, ma'am. I'm showing you that, would you like the individual dates?
Sure.
Okay. The record indicates that he worked on February 4th of 2020 for 8 hours for work crew in Beaumont. February 5th, 2020, worked 2 hours with the work crew in Beaumont. December 10th of 2020, a total of 8 hours, and December 18th, 2020, a total of 4 hours, which was the last entry of when it was service hours.
Do you have any notes in your file that show that Mr. Chambers was employed and maybe engaged in conversation with the office or your office about issues he may have had performing the community service hours while he was working?
Just a moment. So a chronological entry dated for December 1st of 2020 indicates that the defendant spoke to Miss Belinda Rubin, who was his probation officer at the time. And he was, the note states, he was advised to go to the Jefferson County Maintenance Department due to having hours available in evenings and weekends.
Okay. And so as far as you know, no other community service was performed other than the 22 hours that you just testified to, correct?
That is correct.
Okay. Does it show in your file that after these dates that are mentioned in the motion to revoke probation of June 3rd of 2020, July 8th of 2020, August 12th of 2020, September 21st of 2020, does it show where Mr. Chambers failed to report after that?
No.
So is it safe to assume that Mr. Chambers also made a valiant effort to report to probation as directed by the court?
I'm sorry, can you repeat the question?
Is it safe to assume that Mr. Chambers was complying with his order to report to the probation department?
I think there's a mixture there of reporting as directed and then subsequently not reporting as directed.
But according to what you just testified to, there haven't been any other incidents other than the 4 times that he failed to report.
That is correct.
Okay. So were you aware that Mr. Chambers is employed? I was not. Were you aware that Mr. Chambers has a family that he supports? I was not. So it's your position that even though he's been making payments on a regular basis, even though he's attempted to perform his community service hours and he's reported as directed, you still think that should be revoked?
I believe that given the facts that he was not able to complete the court ordered conditions of probation within the originally provided time frame by the court, that failure to do that would result in a recommendation of revocation.
So would you be opposed to Mr. Chambers, since he has been shown, or since he has been showing an effort to comply, would you be opposed to perhaps extending the probation to allow him time to pay his fees?
Yes, I would be opposed.
You would be
I
opposed.
would be opposed.
And why is that?
Based on the fact that he's been reset multiple times with this court to demonstrate a turnaround, if you will, or a change in the reconciliation of these conditions, and has still failed to do so after some time. His probation was set to expire January 13th of 21, and here we are, November of 2022, and still left outstanding conditions.
But he has been paying, correct?
He has, yes.
He's
he has
been reporting.
There were no further entries beyond the January of 2021 report.
Well, so let's go back. He's been paying,
Yes,
okay? And the only thing that's outstanding right now, according to the motion that was filed, is his failure to complete the anger management.
that is not correct. There are allegations.
I'm talking about the, okay, and which motion are you referring to?
There's the one for 322-442 does stipulate the violations mentioned there, one of which including the failure to complete anger management. But on cause number 318966, there is also an outstanding condition to provide completion for the drug education class, which he has not provided any proof of completion for.
So because he hasn't completed the 2 classes, that's enough to revoke in your opinion?
I don't have an opinion on that. I think that when we have cases that we supervise that do not complete it within the original allotted time frame, part of our responsibility as a probation officer is to report that to the court and subsequently make a recommendation on the cases given.
Were you aware that these courses may have conflicted with his work schedule? Were you aware that Mr. Chambers, I know that you mentioned one incident where there's a record of it. Were you aware that Mr. Chambers has been making efforts to contact the DA's office to take these classes?
Can you repeat the question, please?
Were you aware, other than the one time that you mentioned that's recorded in your file, that Mr. Chambers has been making attempts, multiple attempts to take the courses?
I was aware of an attempt for the anger management, but even despite that, that was still outside of the original term of his conditions of probation. But yes, to answer your question specifically, I was aware that he made an attempt to enroll in the Family Services Anger Management Program after his term.
No further questions, Ron.
Okay. Mr. Shearer, you may go forward.
And Mr. Parsons, just I want to go back and paint in one, my understanding then that the last time he performed any community service hours was December 18th of 2020.
That is correct.
So he did not perform any community service hours for the year 2021.
Not according to this record, that is correct.
And he did not perform any community service hours this year.
Not according to this record, that is.
Okay, and when was the last time he reported to y'all's office?
The record indicates that his last time to report was January 4th of 2021.
Okay, so the remainder of 2021, February, March, April, May, June, July, August, September, October, November, December, 11 months in 2021, he did not report.
That is correct.
And in 2022, he has not reported at all.
That is correct, but he was not required to report after the January 13th of 2021 because his case had been referred for a motion to revoke. So he wasn't failing to report as directed, he just was not coming in pending disposition of these cases.
Okay, and when was the last time he made any payment on his cases?
Okay, the last payment that I see reported in the case file was from this month on November 2nd, 2022, in the amount of $127.
And prior to that, what did we do?
The prior entry before that would be August 5th, 2022, and he paid a total of $57 towards cause number 318966. Just want to double check. And then it also appears that a portion that was also diverted to cause number 322442 in the amount of $130. So that would be a total of $187 payment on August. I'm sorry. I had that incorrect. The last entry before that was August 24th in the amount of $130.
Okay, and that was August 24th of this year?
Correct.
Okay. And prior to that?
And then prior to that, that was the entry I was mentioning about being split. Sir?
That was August 5th?
August 5th,
Okay,
correct.
what about the month before?
July 8th in the amount of $50.
Okay, and was there any in June?
No,
Okay, what about going back?
no. The prior entry before July 8th of 2022 appears to be November 22nd of 2021 in the amount of $102.
Okay, as far as the classes, we had 2 classes he was supposed to
Correct.
attend. Okay, the drug class, who is that done for?
There's a couple of different locations that they can configure through. We provide with the pandemic, we were required to provide alternatives for online provisions for the drug education class. And then there's also an option where probationers can complete it in the office, like in the probation building in the evening times, if they're referred in or interdepartmentally. And then there are also other third-party classes that the probation can be referred to.
Okay, and there's no evidence that he attempted to take advantage of any of those?
I have not received any proof of completion for the Texas Drug Offender Education class. And I do see that he was advised of the, he was referred rather for the class during an initial office visit of what appears to be with Ms. Belinda Rubin on February 4th of 2020.
Of 2020?
When he was first placed on probation, a month later, his conditions were originally discussed. He was provided information on where to complete those classes.
Okay.
Okay, Ms. Ms. Carrazzo? Okay. State, you have any other witnesses?
No, Your Honor.
Okay, now, Mr. Parsons, you may step down. May this witness be excused?
Yes, Your Honor.
Defense? Okay, you may be excused.
Yes, sir. Thank you.
You have a blessed day. Okay. State, you rest.
Say rest.
Defense,
Your Honor, I would call Cleveland Chambers.
Mr. Chambers. Mr. Chambers, would you please raise your right hand? Mr. Chambers, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Chambers, you may put your hand down. You may take a seat, Mr. Chambers, and you can adjust the mic. Ms. Perazzo, you may proceed.
Thank you, Lauren. Mr. Chambers, you were placed on probation on January 14th, 2020, is that correct?
Yes, ma'am.
Now, when you were placed on probation, were you working at that time?
No, ma'am, I was not.
And you began your community service kind of sporadically, but you did attempt to perform the community service hours, correct?
Yes, ma'am.
Now, there were also some dates. There were a couple of months in, well, 3 months in the summer and September of 2020 that you did not report. Why did you not report during those months?
Actually, very to myself, wasn't reporting. I've changed. I'm a better person now. I've changed. So if you give me anything about, we'll report.
Well, so it's safe to say that you kind of got off to a
bad
you-
start.
well, you started off good, but at some point you kind of faltered,
Yes, ma'am.
but then you picked back up again.
Yes, ma'am.
And your payments have been sporadic,
Yes,
correct?
ma'am.
Can you explain why you haven't been paying on a regular basis?
The reason I haven't been paying on a regular basis because I got behind on my rent. I was 32 months behind on my rent. I recently just had a daughter. I got a 2-month-old.
Oh, I'm sorry. I forgot what was saying.
Yeah.
I apologize. I just. Okay, I'm sorry. I did not mean to cut you off. Can you repeat that?
Okay.
Why were you having problems making payments?
I was behind on my rent and the rent was not actually acceptable for me to make up the money that I was working at Focus every week to pay him back. And I just recently had a daughter, a 2-month-old. So that was the issue why I couldn't pay on probation. But as of now, I get paid today. I'm gonna make a payment whenever I get it, if I can get up out of here today.
Okay, well, let's kind of slow down just a little bit, because we're gonna get to that in just a minute. Let's talk about the anger management program. When did you ever make attempt
Yes,
to
ma'am.
take this class?
Yes, ma'am. The last time I came to court, it was the day after I came to court, I attempted to give the lady on Fannin a call about anger management, and she said she was going to reach out to my probation officer about it, and she reached out to him about it, and he never gave me a call. I never got a call back.
So it was your understanding that you were supposed to get a call from the probation department directing you where to go?
Yes, ma'am.
And that's according to the probation officer that you spoke with?
Yes, ma'am.
Okay. Did you just try the one time to take the class, or did you try more than once to
I
take
tried
the class?
more than once, but the class didn't match up with my work schedule. So it really, the work schedule that I have, I work at a call center. And basically, by me missing work, they're losing money. So by me missing work and not having a job, I wouldn't be able to pay probation at all, basically. That's basically was the reason, because of my job.
So when you called about the anger management program, did you ever inquire, or was it ever offered that you could take this program online?
It was never offered.
So it was your understanding that it had to be in person?
Yes, ma'am.
And what is your work schedule?
My work schedule, I work Sundays through Fridays, 12 to 9, 12 in the evening to 9 at night.
12 p.m. until 9
Yes,
p.m.?
ma'am. 12 p.m. to 9 p.m.
So were any of these programs, the anger management and the drug and alcohol programs, were those offered before noon?
No, ma'am, it was 6 to 9 p.m. 6 p.m. to 9 p.m.
Did you ever mention to your probation officer that you were having problems taking the class because they conflicted with your work schedule?
Actually, I never gave him a call, which I should have gave him a call. So I could have complied with that, but I never gave him a call. But the lady that I reached out to for Fannin, she did reach out to my probation officer. She did get a notification that I was trying to reach out to him to apply for those, anger management classes.
Now, were you aware that you were supposed to be taking this drug and alcohol, class?
Basically, when I first started the, probation, I was aware. But when I was coming to court, I was never told that. I was always told anger management. I was never told drug class. It was always anger management.
Okay.
That's why I kind of slipped from my mind that I thought I didn't have to take the anger management class. So I didn't have to take the drug class. I thought I just had to take the anger management class.
Okay. Let's talk about the community service hours. Now, the probation officer that is requested by the supervisor of the Pintos, he testified that you only performed 22 hours of your community service. Is that true?
It could be true, but due to I was going to the court office, she was basically helping me out on hours. So I don't know if the hours wasn't just given to me, but I was going to the court office to actually do community service.
Now, was it your understanding that you had completed the community service hours?
Yes, ma'am, it was from my understanding that I have completed community service at office.
When you spoke with your probation officer after you worked at the courthouse and did all these various things, did she ever tell you that you still had community service hours to do?
No, ma'am. It was never told to me that I still had community service hours.
So
I never knew that.
okay, so you thought that you were finished.
Yeah, if I knew it, if I knew I wasn't finished, I would have completed those hours.
How long have you been employed?
I've been employed I've just got employed because I've been out of job for, I've been employed since June of this year.
Where were you employed before that?
Before I was working at Focus, I was working at Popeyes, and I wasn't making as much, so I had to give the probation office what I could, because I do have rent and I had to have a kid and a baby mama that I was looking out for.
Now, do you live with her and your child?
Yes, ma'am.
Okay. Does the mother of your child, does she work?
Currently, she does not work, but she was working. Well, she was working before in 2020. Well, before 2022, in January of 2022, she stopped working in February due to her about to have a kid.
Is she the primary caretaker for your daughter?
Yes, ma'am. Actually, we both are. We live together, so we both take care of her.
She stays at home?
Yes, ma'am.
And takes care
Yes,
of your
ma'am.
daughter?
And I go to work and take care of the kids.
Now, if the court was to revoke you, what would that do to your life and your livelihood?
Christmas coming up, and I mean, my daughter first Christmas, that would really hurt me. And I mean,
You would lose your job.
I would lose my job. I would actually lose my job. I wouldn't be able to pay my rent, wouldn't be able to take care of my child, wouldn't be able to do nothing at all. I wouldn't be able to pay these court fees.
Mr. Chambers, have you been making an effort to pay your fees?
Yes, ma'am, I have.
Have you been making an effort, or did you think that you made the effort that you were required to perform the community service hours?
Yes, ma'am, I say I did, because the hours that I was coming working up here, it actually she was helping us with hours, like I say, but I thought I was getting more hours than I was supposed to, because she's actually helping us with hours, because we'll stay here for about 4 hours, so she'll give us an extra 4 hours just for doing the best job that we could. So I actually thought I was getting more hours than I was.
Would you be willing to do more community service hours if necessary?
Yes, ma'am, on days that I'm off, I will come do community service.
And as far as the programs are concerned, are you, would you be asking the court to allow you, if they could, to take these programs online so it wouldn't conflict with your work schedule?
Yes, ma'am. I will be asking the court to take classes online, because I do work 12 p.m. to 9 p.m. And
when I do, and 12 p.m. and not to 9 p.m., I do have a daughter that I have to take care of at nighttime. Then I wake up extra early in the morning. I barely get sleep, so I will be compliant with it.
Is there anything else that you'd like the court to know and why the court should extend your probation period and give you another chance?
Yes, ma'am. Basically, I'm a changed person. Yeah, I know I understand what I've done in the past, but it's 2000. It's 4 years from now for what I've done, and I'm a changed person. I've got a daughter, and I'm just looking to take care of my daughter and get this probation fees out the way, basically.
Ask the witness.
Sure.
Okay, Mr. Chambers, you told the court you work at a call center,
Yes, sir.
and what are your days that you work?
I work Sunday through Friday,
And, what hours?
12 p.m. to 9 p.m.
Okay. And, so you said that on your days off, you could work community service hours?
Yes, sir.
So on Saturdays be the only day off?
Saturdays, and I could take some Sundays off because I work later on Sundays. I work from 4 p.m. from 4 p.m. to 1 p.m. on Sundays. So I could come in the morning on Sundays.
In the mornings during the week, could you come in?
Yes, sir.
Okay. And, you said that you, were told to go to the court to see, or to the courthouse to see about community service hours through maintenance?
Yeah, I was led to the court to do community service hours. That was way in 2020 though, when I was doing the community service hours.
Okay, where did you go?
I went to the main, it's maybe on the second floor. It's either on the second floor or the first floor, but she's a lady that's sitting in the office down there, and we basically signed in for the community service and you clean up around the court office.
Okay, in the old building, new building?
No, it's the new building, the building that we're currently in.
Okay, on the second floor.
Actually, it's the first floor, I think.
On the first floor.
It's the second floor. It is the second floor. I think it's the second floor.
And did they give you materials to clean with or what?
No, sir. Basically, they gave us gloves and we'll walk around and pick up trash around the building.
Okay. And, how many times did you call to try to get into the anger management class?
Recently, the last time, since I've left the court office, I called that one time, try to get into anger management class. Due to I didn't know who my probation officer was, and I finally found out when I called the probation office that I didn't know Ms. Rubin currently wasn't working there still.
Okay, but apparently misunderstood my question. How many times did you call? To try to get the
I
anger
called
management?
once this year.
So once this year?
Yes, sir.
Okay, so since January, one time you tried to get an anger management. What about last year? Did you call last year?
I mean, I was never told about anger management.
And when did you first find out about anger management?
Sir,
When did you first find
I
out?
first found out about it when I got on probation. I first found out about it.
Okay. But so then how many times did you call trying to get into anger management?
I only called once. Sir.
Okay, and when was that?
That was recently. That was probably 3 months ago.
Okay.
I've also talked to Ms. Rubin about the anger management classes.
How'd you talk to her?
Through phone.
Hmm?
Through phone.
Good phone?
Yes, sir. Whenever she was the probation officer.
Okay, and what'd she tell you?
She led me to it was something that I had to sign up for, and I didn't have the money back that then for it.
Okay. Do you remember not coming to court May 28th of 2019?
Yes, sir.
You missed, what happened then?
Due to failure to appear, but I'm a changed person. I come to court now.
Well, I'm not worried about that. I'm asking what happened then.
Sir,
What happened then? I mean,
I probably forgot about court. I probably was forgetting about it. I probably forgot about it.
Okay. You remember in April of 2021 coming to court and saying that you had a new job?
April when?
Of 2021, April 30th, 2021, came to court and says you had a new job?
No, sir.
You don't remember that?
No, sir.
They reset you for 90 days so that you could, see if you could pay?
Yes, sir.
You remember coming September 3rd, 2021? Reset 90 days so that you could continue to pay?
Sir.
You don't remember that?
No, sir.
No, no.
Ms. Marazza?
I have other questions.
Okay, Mr. Chambers, you may step down.
Yes, sir.
You may be seated. Ms. Marazza, you have any other witnesses?
No, Your Honor.
State, you have a rebuttal?
No, Your Honor.
Okay. Okay. we're gonna go and recess. I need to talk to the attorneys and chambers. Just realized something.